Again, welcome everyone to today's webinar, and I'm very excited about today's topics and speakers, since as far as I can tell, we're delving into some relatively new and uncharted territory here. We're going to explore today the applicability of human rights in the maritime context. As one of our speakers you'll be hearing from shortly, David Hammond, has said, human rights apply at sea as equally as they do on land. And while this may seem obvious to human rights advocates who understand human rights to be universal and applicable to everyone, everywhere, and all the time, few human rights organizations have explored in-depth human rights issues in the maritime context, and specifically in relation to how human rights are affected by maritime industries, such as shipping and transport, offshore resource extraction, fishing, and the provision of maritime security services. Today we want to explore this issue and in particular focus on how the guiding principles apply in the maritime environment. As many of you know, the UN Guiding Principles on Business and Human Rights, penned under the leadership of Special Representative John Ruggie, and unanimously endorsed by the Human Rights Council in 2011, the GPs lay out principles to assist states and companies in implementing the Protect, Respect, and Remedy framework. And that framework details, first of all, the state obligation to ensure that human rights are protected, in particular against infractions by third parties such as economic actors. Second, it identifies the corporate responsibility to respect human rights throughout companies' global operations, including undertaking human rights due diligence processes to identify, prevent, mitigate, and account for how they address their impacts on human rights. And finally, the responsibility of both states and companies to ensure that victims of rights abuses have access to effective remedy. So we'll proceed today in the following fashion. I'll introduce each speaker before they speak. I'm going to do shortened bios, but their full bios are available on our website. And they will provide remarks for about 15 minutes each. And when they have finished, we'll open it up for questions and discussions. We'll be ending today at 3 p.m. Apologies, there was a typo on the flyer. It says we're going to go to 3:30, but we're only going till 3 today, but we should still have sufficient time for discussion. And we'll start with Peter Cook, the Chief Executive Officer of the Security Association for the Maritime Industry, who will provide us with some background on the maritime industry and how business operations, in particular private security provision, face different human rights challenges as well as opportunities on sea versus on land. Next up, David Hammond, founder of the Human Rights at Sea Initiative, will talk to us about the human rights issues that arise in the maritime environment and will introduce his recently launched initiative that explicitly seeks to translate the guiding principles of the maritime industry. And finally, John Bellish, Project Development Manager at One Earth Future, will help us understand and assess various standards that have been developed to regulate the provision of private maritime security, often in response to threats related to piracy. So I will briefly introduce Peter, and then we'll hand things over to Peter. Peter, as I said, is the Chief Executive Officer of the Security Association for the Maritime Industry, SAMI for short. He was an officer in the Royal Marines for 24 years and spent a significant part of his career involved in aspects of maritime security, from maritime counterterrorism to formulating counter-piracy policy and procedures. On leaving the Royal Marines, he managed the London office of a hedge fund company, which set up the first hedge fund in Dubai. He then moved into the security sector and after a short period moved to maritime security. Peter is a founding member of SAMI. So Peter, if you want to take it away, that'd be great. And he has slides that John will be bringing up. Great, we can see the slides. Okay, but we're not hearing Peter.
Peter, can you unmute your microphone?
Peter's saying I'm still muted on the system. So if you could click the microphone symbol. Yeah, try now.
Okay, can everybody hear me?
Yes, perfect. Great. Thanks, Peter.
Brilliant. Right, okay, we're off. First of all, good morning, good afternoon, whatever time zone you're in. As Rebecca very kindly said, my name is Peter Cook and I'm the Chief Executive Officer for SAMI. Before I go any further, I think it would be useful for me to explain what SAMI is. SAMI is an international organization. We have 160 members from more than 40 countries around the globe. By and large, those members are private maritime security companies who are involved in providing armed guards for ships that are transiting the high-risk area, which is the area off the coast of East Africa or the Northwest Indian Ocean region, where piracy really was happening from 2008 and is currently still happening. And also teams are being provided in the region of West Africa, which is far more complex. And also some teams are even now going down into the South China Sea. So we've got 160 members from over 40 countries, which is about 80% of the industry, and that does around about 90% of the business. We are also a non-governmental organization, and we are not-for-profit, so we don't align ourselves with any one country or nation. We are impartial in so much as not one of our directors has any links to one particular maritime security company. And last but by no means least, we are extremely integrated with the maritime industry. And I'll explain really what I mean by that later on, which is very important because we ensure that we listen to them and then pass on to our members what is happening in that area. Okay, can we have the first slide, please? I think we've jumped a few there. Can we go back? Go back. Right, go one forward. There we go. That's brilliant. All right, okay. First of all, the maritime industry is different to land. Why is it different? Well, if you look at the slide in front of you, what you'll see is what I call the commercial shipping drivers. And really, there are three drivers that move trade around the world. Now, before we go any further, there are some facts that ought to be taken on board, really. The first one is that 70% of the globe is covered by seas and oceans. And it is the one thing that connects the continents around the globe is the other seas and oceans. 80% of the population live just within around about 100 kilometers of the sea. And last but by no means least, 90% of everything moves by sea. If it wasn't for the maritime industry, globalization would not have happened and would not continue to develop in the way that it does at the moment. And those are critical points that we have to remember. Okay. So what are the commercial drivers for the commercial shipping industry? And what am I talking about when I talk about the commercial shipping industry? Well, ships are measured in a number of ways, but the way that I'm going to describe is in gross tonnage. Gross tonnage means the cargo carrying capacity of that ship. And that effectively tells us how much cargo it can carry. A statement of the obvious maybe, but it's important. There are more than 82,000 ships of more than 200 gross tons. And if a ship is around about 200 gross tons, it means that she is likely to do blue water or deep water transits, i.e. cross oceans. So that's 82,000 ships. But the average ship owner only owns 7 ships. Of course, you've got your massive ship owners like Maersk, who have a fleet of more than 400, Torm and various others. But a lot of these companies are small cottage industries, as it were, or investors that have decided to invest in a ship as a form of investment. And if they've decided to invest in a ship, the likelihood is that they're not particularly interested or are not good at managing that ship. And so therefore what they will do is they will hand that ship over to a ship manager, and he will manage it in the same way that I own a property in southeast London, but I don't want to have the hassle of the day-to-day managing of the house and the tenant, so I use an agent. That's exactly what they would do. So we look at the top of the triangle there, we see shipping companies. I've just told you about those. Their operators, the ship managers, and last but by no means last, the charterers. Those are the guys that fill the ships with the cargo, whether it be containers, dry cargo such as coal or grain, or wet cargoes such as oil, gas, and other chemicals. Now, at the moment, because of the recession, we have an overcapacity within the shipping industry of around about 20 to 25%. And so, therefore, it's a charterer's market. Of course, that doesn't mean that every 1 in 4, 1 in 5 ships is empty. That's smoothed across the plain. But what it does mean is that charterers can pretty much tell how they're going to do it, and as I say, it's to their advantage. So that's the first group. The second group are the flag states. Now, some of you may recall a phrase used back in the 70s and 80s, which was flags of convenience. The reason for flags of convenience coming round was that certain flags would allow people to join their flags and register ships with their flags so that they could avoid high tax payments. Now, at the moment, they're not called flags of convenience, but that is still a name that hangs around. And the top 3 flags states have 40% of the world shipping on their books. Now, those top 3 flag states are Panama, Liberia, and the Marshall Islands. And each of those flag states, along with the others, are competing for ships to go on their flags. Just to give you an idea on that, the Marshall Islands, an organization that I know quite well, and when I started working with them in 2011, they had 80 million gross tons on their books. This year I went to a party to celebrate the fact they have 100 million gross tons, and their flag is growing at a rate predicted of 6.1%. So they're commercial entities, and they are not, they don't operate in the same way that the United States, the United Kingdom, or a European nation would upon deciding upon what they do. They run what they do in order to make themselves more competitive than some of the other flag states. Now, having said this, they're not pariahs, as some people may have you believe, because the vast majority of the best flag states, or the top flag states, abide with all the IMO regulations in the same way that everybody else does. Then the last thing is the marine insurance industry, and they are there, obviously, to insure the cargo, the ship, and the people that sail the ships. So if you look at that triangle there, there is not one government. The governments sit outside this, and a guy called Martin Stoddart, who wrote The Economics of Shipping, refers to this as a perfect market. So there is very little government involvement, and indeed we're all involved in this because we like the fruits of this particular dynamic, because it provides us with cheap fuel, and as I said, 90% of everything moves by sea. Next slide, please. Now, there's also concern or understanding that security is different on land to that which it is at sea. Why is it different? Well, you'll see, first of all, the title of this slide, Maritime Security is like land security, only the land is blue. This was a comment that was given to me by one of the bigger land security companies that really didn't understand what was happening. Why is it different? Well, on land, you operate under a single jurisdiction, for instance, Iraq or Afghanistan. You have a limited number of stakeholders, normally with representation in that country. There is inevitably a political and often military drive to achieve a desired end state. Back, please. And there are, as there were in Iraq and Afghanistan, a significant number of government contracts. The marine or the maritime industry situation is different. It is multi-jurisdictional. For instance, when a ship sails from Singapore to Rotterdam, she will sail through 16 different jurisdictions, including the flag on her ship. Multiple stakeholders. If you have a 15,000 container ship, she will have more than 14,000 separate business interests. There is a commercial drive to achieve continuum of free trade, which is absolutely important. And then the last and by one of the most important, there are no government contracts. All the contracts are private. Next slide. And therefore, maritime security is a growth industry. I've talked to you about that in one way, but the Clarksons, who are one of the analyst firms, say that the expected growth of the volume of shipping will continue at 4.3% year on year, which means that within the next 12 years we will have had a 50% increase of the volume of trade that moves by sea. Against that backdrop, we have shrinking navies. As an example of that, the US Navy this year will have 4 carrier battle groups at sea, and next year only 2. They're not necessarily the best ships to be fighting piracy with, but it does indicate that there is a reduction in the size of the navies. The cruise liner fleet increased in capacity by 50%, between 2006 and 2010, and by 2018 there'll be sufficient room for 500,000 passengers. And I'm not going to go through the rest of the figures. Safe to say that you can see here that maritime security is a growth industry. And I speak to you at the moment from New York, where I am at meetings with the United Nations and the contact group Piracy off the coast of Somalia, and there is a creeping realization of the importance of maritime security and how much that is going to grow in the coming years, and the fact that people have now really got to start focusing on it. Next slide. And therefore, in the final few minutes, could I have the next slide, please? Thank you. It is now really just to talk about the fact that there have been off the the east coast of Africa, really 3 things that have brought piracy down to a manageable level. The first thing is that the navies have worked together in an unprecedented way in order to cooperate and coordinate their operations to deter piracy without a shadow of a doubt. Secondly, the industry have best management practices, which have also worked to harden the ships and make it more difficult for pirates to attack, and thereby again deter the piracy. But probably the single most important element here is the use of armed guards. And it was really after the incident of the Biscaglia in 2010, when an armed guard team was caught napping and they had to jump overboard, that we saw the move towards armed guards. And armed guards now are successful. Not the current, but one of the previous commanders of EU NAVFOR, Admiral Duncan Potts, said that the private maritime security companies have a 100% record of success, and that continues. And indeed, his chief of staff said that private maritime security companies are part of the solution, not part of the problem. And I foresee that that will continue. We do have new legislation. We have a standardized contract given to us by one of the biggest ship owners called BIMCO. We have the new standard that companies should abide by called ISO PAS 28007, which is now coming in and is working well. And we have the 100 series rules, which I worked on with David Hammond, who you'll hear from later on. So we have a number of these things coming together that shows that we have been pushing the limits. The industry has been pushing the limits to get standardization. I think I will just finish by saying that this is a growth industry. We have started. We are in a process of evolution. We haven't got there completely yet. And that whilst the situation of East Africa may appear to be simple in some ways, the situation of West Africa is far more complex and will continue to be for the foreseeable future. I hope that you found that interesting, and of course at the end I'm very happy to answer questions on anything that I have spoken about. Thank you.
Great, thank you, Peter. And actually, I'm glad you mentioned that, because one question that came to my mind was about the changing nature of piracy and how different it is off the east coast of Africa versus the west coast. But perhaps we can get to that more in the Q&A. And thank you for that really enlightening presentation, because I think for those of us who are new to the maritime industry, that's really helpful for understanding some of the differences between business on land and business at sea. So thank you. Okay. Well, we're going to move on next to David Hammond, and Peter actually provided a bit of a segue, because Peter Hammond is the primary author of the 100 series rules for the use of force. And David is a barrister at law at 9 Bedford Row International, where he leads the maritime practice. And beyond being the author of the 100 Series Rules for the Use of Force, he is also the founder and architect of the new Human Rights at Sea initiative. He acts as UK counsel to the Libyan National Council for Civil Liberties and Human Rights in Tripoli, where he drafted the Declaration of Adoption of the UN Guiding Principles for Business and Human Rights in Libya, a first for human rights in Africa. And he is a former frontline Royal Marines officer, naval helicopter pilot, and head maritime lawyer to the United Kingdom's Chief of Joint Operations for Counter-Piracy Matters, among other sensitive issues. David is actively involved in a number of organizations, including as an associate research fellow at the Greenwich Maritime Institute and as a fellow of the Royal Aeronautical Society, and he is a qualified international mediator. And actually, David is also many more other things, but I just direct you to the full bio on our website. And David, it looks like you have the screen, so if you want to proceed, let's go ahead.
Rebecca, thank you, and good afternoon, good evening to everybody who has dialed in. Firstly, thank you to Rebecca and to John, and indeed the University Washington College of Law for hosting this seminar. My background has been more than covered. Suffice to say that I would like to focus tonight on the Human Rights at Sea international initiative. And just to manage expectations, what I'm going to cover is going to really look at the video introduction that many of you have probably already seen, but encapsulates what we are trying to achieve with the initiative, looking at the need for the Human Rights at Sea initiative in the first instance, why the need for business and human rights within the maritime environment, looking at the UN Guiding Principles very briefly, but when I say looking at the Guiding Principles, I'm not going to rehash or go through what we already know, but what I want to do is put it into the context of the HRAS initiative and how we intend to develop it. Give you a quick run through the website as an overview for those people who have maybe skimmed it. Within the last 5 weeks, we have had over 4,000 unique hits, and we have had people averaging 2 to 3 minutes on the site. I will cover then the aim, scope, vision, and timeline. Give you some examples of one of the reasons why I believe that this is going to become more mandatory than a voluntary issue, that being integrating the guiding principles into business in the maritime, and then just give you some headline takeaways if I may. So assuming this is going to work, I just want to run through the Human Rights at Sea introductory video. Health warning, you might need to adjust your volume on your own screens. Okay, so hopefully I can get back to where I was. And the video itself encapsulates, as I say, everything that I want to achieve with the Human Rights at Sea initiative. But why the need? Well, as has been mentioned, the starting point was really the 100 Series rules for the use of force as an independent model, international model set of lawful use of force at sea by private security company operatives. And during the development, along with the likes of SAMI and the International Chamber of Shipping and the Marshall Islands Flag Registry, amongst others, as well as BIMCO, we were very mindful of the background issue of human rights and the need to protect not just the individual pulling the trigger, if so necessary, but also the corporate chain responsibility, and also the indigenous seafarers. And so the issue of human rights and lawful use of force very much sits hand in hand. And as those who are familiar will know from the Universal Declaration of Human Rights, that's Article 3, that everybody has the right to life, liberty and security of person. So I undertook further research and found that had you undertaken a web search and typed in human rights at sea, there was no singular independent platform that brought the matters of human rights at sea together, and hence the initiative was born. There are many very, very good separate international initiatives, but they're not necessarily linked to one another, and indeed may not need to be linked to one another. But I certainly felt, and those who worked with me felt, that in this age of instant gratification, as I find that most people will pick up and Google a question, there was a need for such a platform as the Human Rights at Sea platform. And so therefore we're an independent and privately funded international platform looking to raise awareness and issues concerning human rights at sea. We work collegiately. We don't work against other international bodies, we work with them. And there will be disagreements and differences of opinion, but that is indeed part of the process. In terms of the UN Guiding Principles, well, why the need in the maritime environment? I will come on and deal with that in greater detail. But the issue is quite simply one that they have yet to be, I will use the term marinized, and applied to the maritime environment. And again, that is an area of work that we're looking at doing. So turning to the issue of business and human rights of business and within the maritime environment, Peter Cook has very ably identified the enormity of the business operations and interactions and contractual matters, indeed litigation as well, that goes on within the maritime industry. The guiding principles, for those who aren't aware, but to remind those who are, were unanimously endorsed in June 2011. Now, the unanimous nature of that endorsement, I believe, says a lot as to the weighting that should be applied to the soft law principles. And indeed, as it says there, they're a reference point for the understanding of respective duties and responsibilities. Obviously, protect from the state, respect from business, and remedy for the individual. Now, there's only one state that has ratified the guiding principles, and that's the UK in September of last year. And that's part of the UK's National Action Plan on Business and Human Rights. Of course, that includes the UK maritime sector. But I'm not going to be Anglo-centric at all, because this is an international organisation. My colleagues in Germany have indicated that the federal government, in terms of its treaty agenda, is also supportive of the concepts and looking towards potential implementation of the UN Guiding Principles, and that was as of last year. So as I've mentioned, the Guiding Principles, as we know, are soft law, but my position and the position of our team is one that it's the only viable option for dealing with the issues or the subject of business and human rights in the maritime environment at this time. And indeed, there's no reason not to work with them. 193 members can't be wrong. Well, they could be, but I would suggest that it's unlikely that they would be wrong in endorsing John Ruggie's excellent work and indeed the shift team that drafted it. So the initiative, the Human Rights at Sea initiative, has voluntarily taken on this challenge of independently interpreting the guiding principles in the maritime environment. Now, mindful of the time, what I'd like to do is just take you to the site itself and just cover a number of matters. Just bear with me while I expand this window. So standard site, homepage covering the launch as of the 3rd of April in London was well attended, and we provide, as a matter of clarity and transparency, indeed accountability of our work, access to all materials here on in. The developing work areas, which I'll just come back to, we've obviously seen the video, and as I scroll down the screen, I do hope many of you had the chance to read the welcome text outlining our underlying principle that human, as is in bold there, that or the proposition rather, that human rights apply at sea as equally as they do on land. Our aim is very simple. It's to raise the profile, awareness and implementation and accountability for human rights protections throughout the maritime industry, and particularly not within the boardroom environments, but by those people who are on the receiving end of the abuse as well. We have a fourfold vision of increasing global awareness, international development of remedies, the issue of lobbying on pertinent maritime initiatives, and indeed global awareness of the guiding principles within the maritime context. We keep an up-to-date news and indeed blog page and a number of events which we'll be involved in as I scroll down. And some of you may have come across the way that we have been building our support through the supporting entities and collaborative partnerships. The supporting entities are simply those entities that have agreed with our proposition and support the initiative in its whole, and the collaborative partners are those who are deep diving into particular work areas, which I'll come back to. We have a number of supporting entities. They are growing from not just from the various industry associations and academia, to lawyers, to international accounting, reporting assurance clients, as well as California Maritime Institute, and most recently, I'm very pleased to be able to welcome on board the Walk Free movement, anti-slavery movement of 6.5 million members, are growing daily, and the New Zealand NGO Slave Free Seas. So I'm just going to scroll back up the screen and take you back to the developing work areas. One of the points about this initiative, which is 5 weeks old, is that this site is a work in progress. The developing work areas are very much going to be developed themselves and will be broken down into international projects. And if you can see my mouse on the screen, they will cover the children's rights at sea area, West Africa, initiatives that are being drafted at the moment, as well as the slavery initiative, which I've just introduced. We'll be looking at corporate social responsibility documentation, which will cover the model guiding principles and best practice, the issues of human rights impact assessments and their application within contractual negotiations, and also a legal review, not an advice, but a legal review as to the aforementioned best guiding principles and human rights impact assessments. As I draw breath, just to note that for 30 plus years we've been undertaking environmental impact assessments and social impact assessments within corporations when going into new business markets. I am of the position that there should be no reason why we should not have human rights impact assessments, and the problem we have is that we don't have a model, and that is hence the work that we are doing within that work area. It's all well and good having the UN Guiding Principles, but without an implementing framework and then a feedback loop in terms of the reporting and assurance, then they stand alone. The implementing framework, I'll just click on this window for example here, is being supported by a key collaborative partner, that is Mazars LLP. They are an accounting, auditing and assurance firm, and they have a huge amount of experience within this area and indeed within the reporting and accounting area for the UN guiding principles. So just going back, that is the website in a nutshell. We have all the usual about us, resources, archives, blogs, and I would draw your attention as I use my mouse here on the frequently asked questions, which should answer a lot of your immediate questions as to our work. So I'm going to just go back to the main PowerPoint presentation, and I just want to run you very quickly through some examples of the integration of human rights in business and general awareness. Now, 2 days ago, reported by Phil Bloomer, who is the Business and Human Rights Resource Centre's executive, he was quoted as talking about the issue of transparency within the Myanmar business and corporate businesses and business processes. The transparency is, as he says, an essential first step to underpinning, and as it goes on to speak about corruption, improve companies' position, and indeed issues on human rights. So this is an international issue. Further, we have the example of the Maritime Legal Convention. The MLC 2006, and the reason I put this up is that the Executive Director of Seafarers' Rights International, Mrs. Deirdre Fitzpatrick, has made the point that seafarers themselves are not sufficiently aware of their rights, and it's one of the points of the Human Rights Initiative that we are seeking to promote awareness, not in this case of the MLC but per se, but rather of human rights in particular. The European Parliament has amended the Council Directive on the disclosure of non-financial and diversity information. The article there, Article 19A, in terms of the non-financial statements, which is expecting next year to become law and therefore mandatory, not voluntary, should have as part of the non-financial statement for companies the outline of the understanding undertakings in relation to respect for human rights. Of course, that is the second pillar of the guiding principles. India's New Companies Act 2013, which was implemented this year, has in a nutshell said that in terms of profits, 2% should be spent on corporate social responsibility. In my mind, that is certainly certainly includes human rights, and I would assert the UN guiding principles and best practice for business. So my final slide. These are my takeaways that I would just like to provide the audience. As I said, we are a new and independent international initiative. We are work in progress, and we are looking, and indeed we already have, as you will have seen from the supporting entities, a large amount of international support. We are expanding, and I am in contact and indeed negotiations with a number of other big initiatives, human rights initiatives, to hopefully come on board, again from the collegiate position. I'm not going to say that we immediately have all the questions and all the answers to the questions posed, but we are working in the right direction, and again we seek support from around the world. The front and centre position of the UN guiding principles is one that we feel underpins certainly best practice for business within the maritime sector, and it goes to the issues of corporate social responsibility. And we also believe in that underlying proposition that human rights apply at sea as equally as they do on land. I've covered the issue that we believe in working collegiately, not against, but with people, and we are here to assist as another international platform. And finally, we are continually seeking external support and funding sources, and that is to keep our momentum going, though I have to say I could split myself into 10 and not cover all the work. So that is my brief presentation. I'm sorry, Rebecca, I am 2 minutes over.
Thank you, David. No worries at all. We're good on our time. It's helpful, so it leaves plenty of room for discussion. And thank you for presenting us information on your really exciting new initiative. And I encourage anyone who's interested, I hope this is okay, David, to reach out and contact you to share any ideas or thoughts or support that they might have. And also thank you for sharing with us, all this evidence of the UNGPs finding its way into hard law. And I think maybe during discussion, it'd be interesting to hear some more from you to the extent to which those different stakeholders in the maritime industry are aware of the guiding principles, or whether you're really starting from scratch. So perhaps it's something we can touch on in the discussion. Okay, so I'm going to turn now to John Bellish. John, if you could hand over the screen to John, that'd be great. John Bellish is the Project Development Manager at One Earth Future in Colorado, where he designs various strategic initiatives for the organization. And prior to his current role, he was the Project Officer at Oceans Beyond Piracy, in charge of legal issues related to maritime piracy and the provision of private security services. And he's also currently serving as a research fellow at the Nanda Center for International and Comparative Law at the University of Denver. So thanks, John. You want to take it away? Go ahead. I think there seems to be, if you're speaking, John, we can't hear you.
How about now?
Yes, wonderful. Now
Rebecca?
we can hear you. Yes, we can hear you. Great.
Okay. Well, thank you, Rebecca and Peter and David, and good afternoon to everybody else. I think I'm pretty safe in using afternoon out here in the western United States, but there could be some real troopers even further west than me. I today want to talk briefly about the various sources of regulation bearing down upon the private security industry, both to sort of demonstrate the difficulty in ensuring respect for human rights at sea, as has been alluded to by Peter and is, of course, the subject of David's work, and then also just briefly outline a few of the steps being taken by the international community to ensure respect for human rights at sea. Before I get started, just wanted to run through a few brief trends and statistics. Oceans Beyond Piracy released our 2013 State of Piracy report on May 7th. The sort of headline finding was that the cost of Somali piracy was down around 50% to $3.2 billion from around $6 billion last year. But there were also a few trends specific to the private security industry that I thought were worth mentioning. As you can see, the one trend that we observed was a reduction in size of the security teams from not universal, but nearly universal use of a 4 to 5 man team in the sort of early days to this year, where our researchers found that around 40% of companies were using teams with fewer than four team members, and the remaining were using the larger teams. The next sort of trend that we observed was a decrease in the rate of use of private security, which is not terribly surprising when you consider the reduced incidence, but is nonetheless something to keep an eye on. The third trend was a move that we have been observing in the last couple of years towards the use of so-called mixed teams, with a British team leader or a team leader from the EU or the US, and the rest of the team from a second country, or even a number of other countries. The kind of leaders in that category were Greece, Ukraine, India, Nepal, and the Philippines. The final trend is that the use of floating armories remains prevalent. And for those of you not quite as familiar with the industry, floating armories are basically what they sound like. They're ships that are anchored further than 12 nautical miles off the coast of a littoral state, and they're made available either to rent space to store weapons, or certain companies operate their own internally. This is a somewhat controversial practice. It's certain port states are of course quite comfortable with it. It provides an additional revenue source, and it also keeps small arms traffic within the actual port to a minimum. But certain other littoral states, particularly India, have raised some concerns about the prevalence of small arms off their coast in general. Based on our research, there are about 15 to 20 floating armories operating in the high-risk area. The three principal floating armories are, as you can see on the map, represented by the three orange dots, one off the coast of Djibouti, one off the coast of Muscat and Oman, and then the third off the coast of Sri Lanka. So as you can see, there is a real multiplicity of jurisdictions and interests at play. I think Peter and David both mentioned the sort of complexity that arises, but it's a particular issue in the human rights context. It's no longer simply a question, is this jurisdiction able and willing to provide for its citizens human rights? There's an additional sort of coordination problem. Multiple jurisdictions, multiple capacities, all operating in the same space. So that just results in another layer of complexity, making regulation of the industry that much more difficult. Nonetheless, there have been numerous attempts to provide guidance. These are the types of regulation that I'll cover today. A couple of foundational documents, a whole plethora of national laws that could be applicable, some voluntary guidance from the IMO, and I'll also mention David Hammond's initiatives, some model contracts, industry groups, and industry standards. I won't spend too much time on the foundational documents. David did a great job making the UN guiding principles relevant to the maritime sector. But this is, of course, a big component of the entire regulatory effort, ensuring protection for human rights in a complex environment, one where monitoring is particularly difficult. The next foundational document is the Montreux document on private military and security companies, signed in 2008, designed to provide guidance to states regarding the use of private security companies during an armed conflict. A great deal of useful information contained in the Montreux document, but it is not directly relevant, at least presently, to the provision of maritime security services. Not only is there no armed conflict under international humanitarian law between private security companies and pirates, but also because, as Peter mentioned, these are essentially private contracts. So the guidance contained in the Montreux document for states may not be directly applicable to a contract between two private parties. The next slide that, again, I won't spend too much time on because I think Peter did a good job outlining the complexity involved, but you can see there's a multitude of countries with different positions on the use of private security companies. So any ship operator or owner operating in a high-risk area has to deal with flag state laws, maybe the laws of the home company, the laws of the home company for the private security company in question may be relevant, and then the laws of the coastal state of any nation that the vessel passes through during transit. They'll all be relevant. So this again just illustrates the coordination problem, the many moving parts, especially at the national level when considering a large-scale commercial shipping operation. So in part to help overcome the diversity in national laws, over the last couple of years, the IMO has released a number of circulars providing guidance to various groups, from ship owners to flag states and coastal states, and even the maritime security companies themselves. As is the case for all MSC circulars. These are non-binding. They're just meant to provide guidance to various groups in hopes of some sort of marginal standardization. Then we have other voluntary guidelines led, as we just heard, by David Hammond. He's spent plenty of time on human rights at sea, and I am not nearly as qualified as he to speak to that issue. The only other thing that I'll raise is he and Peter worked on the 100 series rules on the use of force, meant to be a model set of best practices for the use of force based on principles of international law and general principles of the criminal law. These are non-binding. They don't create any new international obligations. They're meant to be incorporated into private contracts or other international standards. The key model contract dealing with private maritime security is BIMCO's GuardCon. It doesn't seek to directly affect the operation of a private maritime security company. Rather, it's meant to provide clarity on the division of responsibilities between the ship owner and the security provider. It's meant to be a starting point, meant to be modified as needed. But again, this is just another example of entities operating in this space working to standardize and streamline what is necessarily a messy, complicated process. The next sort of source of regulation, loosely speaking, are industry groups. We heard from Peter about SAMI. The only thing that I would add is that there's also a certification component. I checked the SAMI's website this morning, and it seems like they have about 70 companies certified, and then another 70 or 75 awaiting certification. So even though SAMI has a number of purposes beyond providing a regulatory function, the certification requirements serve to, at the very least, sort of implicitly complement other types of regulatory efforts. The next group that I'm going to talk about kind of sits in the middle of an industry group and an industry standard, the International Code of Conduct for Private Security Providers. So the Code of Conduct itself is a document that speaks to issues such as vetting personnel, training them, keeping adequate records, maintaining an adequate level of insurance coverage, having systems in place to deal with proper incident reporting, third-party complaint mechanisms. It also has a number of explicit references to international human rights standards. This, the ICOC is accompanied by the ICOCA, I'm getting ahead of myself, by the ICOCA, which is a three-pillar enforcement mechanism. It's basically a tripartite structure organized as an NGO but made up of actual private security companies, governments, and civil society organizations who all work together to develop and enforce actionable standards as they relate to the code itself. And then the final category of sources of regulation are industry standards. The first that I'll discuss is the ISO PAS 28007. It was created through the International Organization for Standardization. It is currently has been accepted by the ISO as a publicly available specification, which means that it's essentially undergoing a trial period. There have been a number of UK entities that have been accepted as certification bodies, so they are auditing companies that wish to be exposed at an early stage to the qualification requirements of the 28007, and there have already been a handful of companies certified to the publicly available specification. What needs to happen next then, if the ISO agrees, it will be voted into a sort of full international standard with all the characteristics that are associated with that. And then there will be some sort of arrangement made for those companies who have been provisionally certified to the publicly available specification. Of course, new companies wishing to come on will then be audited to the ISO standard and accepted as being qualified. The next set of standards is the ANSI PSC 1 through 4 standards. These standards were developed by ASIS and ANSI, American national standards making bodies. This set of standards is currently in the process of being converted to an ISO national standard. Not quite as far along as a 28007, but undergoing a similar, though not identical, process. The PSC standard is, well, only one part of the 1 through 4 is written specifically for maritime security companies. It's currently unclear what the relationship between the ICOC, the 28007, and then the PSC standards is going to be. I feel pretty comfortable in saying that the ultimate decider, absent some large outside intervention from a government or a group of governments, is going to be essentially industry uptake. The values of each of these standards and systems will be judged essentially on their practical utility in terms of effectively regulating the company in a cost-effective way and in a way that is agreeable to clients. So I think it's too soon to tell how it's all going to shake out, but it is a process that is currently underway. I think, yeah, so I'll finish just by briefly mentioning that West Africa is a very different, just a different ballgame. The majority of attacks occur within 12 nautical miles from the coast, bringing them under control of the coastal state. The current sort of state practice in the Gulf of Guinea is that merchant vessels are required to use state-sanctioned private security companies, rendering some of these international efforts less relevant on the west coast than they were on the east, and again further complicating the situation. In terms of the regulatory framework, because of the geographic location of the bulk of the attacks, the national laws of the coastal state will ultimately be the most important source of regulation. With that said, other groups are stepping in to guide that process. BIMCO has developed a model contract for West Africa. The IMO has endorsed a set of industry best practices, and as David mentioned, his group has a dedicated track for West African provision of security and respect for human rights. So I think that leaves us with about 20 minutes or almost 30 minutes for questions. So I will cut it short and we can get to discussion.
Thanks. Thanks so much, John. Really, all three speakers for keeping us on time. And John, thank you for undertaking a not very easy task, but doing it very well in terms of laying out that complex regulatory landscape. And perhaps in the Q&A, we could talk a little bit about something that's always been of interest to me, and that's whether or not this kind of proliferation is problematic. You know, are these standards competitive, complementary? You talked about some beginning evidence of convergence or standardization. You know, who or what are the drivers behind that, if that's occurring? And also, I think you touched on, and perhaps can elaborate a bit about the interesting nature of the interactions between the different standards. So thank you, and thanks to all of our speakers. So what I would suggest now is let's open it up for Q&A. Raise that virtual hand of yours if you have a question, and John will unmute you. And we have 3 questions in the queue right now. It looks like we've got Zach Butler, Mort Winston, then Ian Ralby. So John, if you want to go ahead and let's start with Zach and unmute him. And speakers, you should, if you have a question directed at a particular speaker, please, say so, but all speakers should feel free to comment on the questions and or each other's presentations as well. So, okay, Zach, are you there? Let's see. John, is Zach unmuted or? Okay. Zach, can you hear us? Okay. John, why don't we try, while we're figuring out what's going on with Zach's microphone, can we try unmuting Morton Winston?
Can you hear me?
Yes.
Hello?
Hi, Mort. We can hear you. Thanks, Mort. Go ahead.
Oh, great. All right. So thanks for your presentations. They were very informative. I served for several years on the advisory board of Social Accountability International, which is known for the SA 8000 labor rights standard. We had a proposal to try to modify it and adapt it to maritime a few years ago, but it sort of died on the vine because there seemed to be lack of industry interest in that or support for piloting. So can any of you comment on what the current environment is, your take on whether or not the industry would be more supportive of a code like SA 8000 for maritime vessels?
Okay, thanks for that question, Mort. Did anyone want to pick up on that issue?
Maybe I'll jump in if I may.
Sure,
Morton, thank you very much. It's David. Thank you.
Oh, sorry, David. Yeah.
Thank you for the question, Morton. From my perspective, and certainly the work that we're drafting at the moment, the industry, when I say the industry, the maritime industry, I'm talking more in terms of the ship owning industry and the marine insurance side of the industry is lukewarm to the CSR and certainly the work that we're proposing.
That's what I thought. All right.
Yeah, the bottom line is the bottom line. And a lot of people have said to me, why do we need another layer of seeming regulation in relation to human rights when actually we are compliant? My answer to that is quite simply, as part of the UN Guiding Principles say, is to know and show. And part of that is the reporting and the assurance. It's going to be an uphill struggle, is the nutshell.
All right. Well, thank you. That confirms my impression.
If I can just jump in here as well, I've been with industry members for the past couple of days and will continue to be for a while. I think that their overriding concern that they have voiced to me, and I'm sure that David is fully aware of this, is that they see that with regards to the handling of stowaways, the handling of smuggling and various other things that they have to cover within maritime security, that all of those areas are quite complex, and what they don't want to see is something that undoes some of the very good work that they have done there. Now, I know that one of the things that David has said is that this is a project that's going to take him 10 years, and so therefore, he's going to have the time to ensure that they are mutually supportive rather than working against each other. But he is quite right. The maritime industry is extremely conservative and doesn't pick up on anything, particularly quickly. The going rate at the moment, if you introduce a new standard to the maritime industry for all flags to adopt it, is about 10 years.
Well, thank you.
Okay, thanks for that question. John, do we want to try to see if we can get Zach Butler unmuted one more time? So Zach, can you pose your question if you can speak now? He's unmuted. Zach, you should be unmuted if you want to go ahead. Okay. For some reason, that does not seem to be working. Zach, if you want to type your question in the chat box to John, John could read it out to us. In the interim, John, do you want to try unmuting Ian Ralby?
Hello, can you hear me?
Yes, hi Ian, we can hear you. Go ahead.
Thanks very much. Thanks to all three of you for the time and effort you put into the presentations. Unfortunately, I have to say I was a bit disappointed with the substance, or in some cases the lack thereof. I mean, one of the things that I found a bit worrying was the notion that underscored this entire discussion was that human rights are as applicable at the sea as they are on land. But I haven't heard any substantive discussion as to what basis there is for that, either in law or in policy practice. And there was very little discussion of human rights as a substantive factor. I think it's worth noting the ICOC was somewhat written off as a mix of a trade association and an industry standard, and I think that's inaccurate. I think I'm not a huge, overly enthusiastic proponent of the ICOC, but it's worth noting what its real significance was. While John did a nice job of mentioning some of the things that it covers, the real substance of the ICOC was to have companies, private companies, independently and voluntarily commit themselves to human rights principles which were not necessarily applicable to them by law. And I think he unfortunately used the term enforcement mechanism, which is not quite what the ICOC Association was intended to be. But the point is that human rights, at least at the international level, are incumbent on states, not private actors. States are therefore responsible for translating those international human rights principles to individuals and companies through their laws. And the extent to which law is applicable on the high seas is pretty much the extent to which we're talking about the implementation of those human rights principles. So the ICOC, and I've published on this, may not be applicable to the maritime context in its terms, and in fact, I will raise my hand and say I was the one that suggested it not be initially. I think Chris Mayer can back me up on that. But from a substantive standpoint, that choice by companies to commit themselves to human rights principles that were not applied to them through law was really quite significant. And I haven't heard anything about that substantive factor. So I would really welcome some mention of what it is that we're really talking about substantively. Are we talking about law? Are we talking about just notions of good practice? And how do we really see this taking some shape? Because we've heard a lot about the private security industry, but I think there's a lot more to it than that. So sorry for being a bit negative, but I'd just like to hear a bit more in the way of substance.
No, thank you, Ian. Thank you for those very pointed questions. I think you raised some interesting issues here. I'm just going to open it up. David, John, Peter, who wants to jump in first and respond?
It's David. I'm very happy to jump in. Ian and I are known to each other, and I know Ian has taken adverse stances to my previous work, and which, of course, he's entitled to. So to pick up on the points that were very fairly raised by Ian. Firstly, in terms of substance, we have 15 minutes to cover a huge subject. So in terms of substance, I'm sorry that you felt disappointed, but of course we're always happy to engage with you offline. The issue about application in law, certainly from the position of the Human Rights at Sea initiative, is one that we are not trying to create law. That's made very clear on the website. I'm sure you've read the front page of the welcome note. It is an issue to pick up on, to adopt your words, of one of notions of best practice and good practice, referring back to, in terms of business and human rights in the maritime environment, the guiding principles, which are soft law, they are voluntary, but they are the best we have. But just to pick up on where does it stand in law, well, if we look at Article 2 of the Universal Declaration of Human Rights, and I can read it out, but I'm sure those who are online now can pick that up on a Google search very quickly. The Article 2 is applicable in terms of being everywhere in terms of international states, jurisdictions, and basis of the political position of the people that it's entitled to, and that is everybody. So the proposition that human rights apply at sea as equally as they do at land is based upon the Universal Declaration of Human Rights and Article 2. It's simply an interpretation of that. It certainly does not get involved in any issues of the spat between ICOC and the ISO PAS 28007, which is another issue I'm sure Peter or John may pick up on. And in terms of the application through law, I did highlight the EU directive, which will become law, which will apply to 27 member states, nations. And indeed, within the UK Companies Act last October, the 1st of October, there was a change in, there was an addition of secondary legislation, which made it clear that if the work that the company was undertaking was material to reporting on human rights, then as a point of law, within UK companies' annual director's report, they were therefore required, if it was material, to report on the likes of their position on human rights. So actually, Ian's point that in terms of it not being substantive is actually, in my view, not fully correct. But again, we only have 15 minutes to discuss that. So those are my points.
And then I'll jump in just really
John?
briefly.
Sure.
Rebecca, can you hear me?
Yeah, John, we can hear you.
Oh, so I just wanted to briefly jump in defense of the statement that human rights applies on sea as it does on land. I find that to be a perfectly apt statement. Ian is right that it is a state's responsibility to enforce norms of human rights, and that's true whether they're enforcing it vis-a-vis a natural or legal person on land or a natural or legal person at sea. It certainly still has to run through the state. So here it's a question of differences in a practical ability to enforce human rights norms upon corporations registered in a state or upon individual citizens of that state. And both in its sort of, it applies equally on land at sea, both in the positive sense and in the negative sense. And then really briefly on the ICOC, I misspoke to an extent in describing it as an enforcement entity. The ICOC is an enforcement entity. They're charged with enforcing respect and compliance with the ICOC. So the ICOCA has the power to accept and expel members based on observed compliance. So of course they don't have traditional police powers, but they do have a certain amount, of course, of authority over its own members.
Rebecca, may I just respond very quickly to one thing David brought up?
Sure, go ahead.
Just a very, very quick point, Irene, to underscore, I think, what I was getting at, is that I'm not questioning the laws that are encouraging application of the UN guiding principles on business and human rights. Fine, but that's a framework. I'm still looking at the substance that seems to be a question mark. I think the ISO PAS 28007 was brought up just a moment ago. And I know I've heard Peter say this a number of times that it mentions human rights 12 times, but that's if you count the footnotes and documents it's referencing. In terms of the substantive matter, it doesn't actually reference it more than once and only in almost an offhand way. And it doesn't go that extra step of saying, look, even if the laws don't translate these human rights principles to private companies, we're going to require it as a matter of this standard. So there's a lot of substance that I'm trying to draw out here, and I'm not being critical of this initiative. I'm saying let's actually engage these issues, because I think there are real concerns that need to be discussed and need to be addressed. So please don't get me wrong. And the reason I'm critical of RUF 100 is a sort of completely separate thing, and I don't really think that was a human rights initiative. So let's just keep those separate for now.
Yeah, Ian, if I can just come in there, the fact is that there are, and I can't remember exactly how many areas there are a number of areas where it refers to national and international conventions and laws, and that's what I'm referring to, because there are so many that may apply. And I think that gives it the flexibility without necessarily tying it down. But the beauty of it being a PAS is that it is an evolving beast, and therefore, you know, as we go forward and things become slightly clearer and better, and just one example of that was that when the IMO tasked us to write it, it was restricted to East Africa and the high-risk area, but as we've heard, West Africa is becoming an increasing problem that requires some form of similar standard. So therefore, it can be hopefully it can evolve into something that will work in a similar way in the West African theatre.
Rebecca, it's David. I just wanted to just jump in support of actually what Ian was saying in terms of substance. Ian and other members on the webinar, I don't know if you're aware of the Shift project. If you go to shiftproject.org, they are actually partnered with one of my partners, that's Mazars, and they are developing with a very large industry stakeholder group the Human Rights Reporting Assurance Frameworks Initiative. That has been endorsed by the UN Guiding Principles Working Group, and indeed it is part of the Association of Southeast Asian Nations as well, and is underscored by the Human Rights Resource Centre, where they are looking in terms of actually providing implementation and framework to the guiding principles, which of course is not legislated as against, but it goes back to the notion that Ian was talking about, one of good practice, but more formalisation of that good practice. Thank you.
Great, thank you. If anyone has any questions, go ahead and raise their hands. I'm going to turn to John and ask, are there any more questions currently? Otherwise, I may jump in with some of my own questions. So it looks like there's no other questions. Okay, good. So I just wanted to actually pick up on something John had said earlier. So, and Peter, you seem to indicate this as well, you know, with the idea that the PAS is, you know, an evolving standard. So I guess my question is, there's multiple questions here actually at once. The first is just to understand, so do you all have the sense that there is actually a relative high level of awareness about the guiding principles in the maritime industry among stakeholders? You know, because one of the things, I think those of us who work in business and human rights, we tend to think that since we're very familiar with the guiding principles, everyone must be as well. And then when you actually go out, you know, and talk to a number of you know, senior management in businesses and companies, you realize that perhaps there isn't that great level of awareness. So I'm just curious, you know, obviously, David, your initiative is geared towards that very outcome and raising awareness, but what do you think the current level of awareness is? And then along those lines, you know, we were talking a little bit, you know, in light of Ian's questions about the differences between hard and soft law, and I think sometimes that distinction is overemphasized, and we see a lot of ways how soft law is, you know, becomes part of hard law. You know, one example being, for example, that the DoD requires PSC1 as part of its procurement policy, and it's then embedded in contractual obligations. So do you see any evidence that, at least when it comes to maritime law, that there's, or even voluntary maritime standard, that there's now a growing consideration of the GPs and perhaps a re-examination of existing standards in light of the GP's principles? And then I'm going to actually, before you guys respond to that, I'm going to ask John to unmute Chris Mayer, and I'll let Chris Mayer tag on his question to that, and then close with a round of responses from all three of you.
Hi, this is Chris Mayer. I just wanted to, Rebecca, you made a really good point. I just want to bring on to what Paul or Peter said too, is about the PAS being a PAS. It's not actually a full international standard yet. And we understand that a publicly available specification is passed because there is a urgent and imminent need for a standard. I think we're in absolute agreement. There was an urgent and imminent need for a standard. While we're doing this, we're still working out exactly what human rights things apply within the maritime context in which they don't. Yes, Ian was one of the people who stood up there and said that the ICOC does not directly apply to the maritime industry. At that time, we said, there's about 25% of the stuff in the ICOC that might not apply. There's about 25% of stuff that we haven't captured yet. But for the most of it, we do. What I'm hoping for is as we move through the paths becoming a standard, we use the ISO development process to make sure that we capture all of those developments, all of those things that we've learned, so that we can take the best of the ISO 28007, the things that are in PSC4, the things we're learning from implementing PSC1, and actually have something which can be used, which can be written into contracts, and can be enforced by states in their proper sovereign role. Thank you.
Thank you, Chris. I think you raised some excellent points there. So I'm just going to ask, we'll go in the order that, because we've only got 5 minutes left, if we perhaps go in the order that was presented, starting with Peter and then David and John. Maybe you could make any closing observations and remarks or answer any questions perhaps that you wanted to answer but weren't asked. So we'll start with you, Peter.
Okay, well, thanks very much, Rebecca. And thank you also to the people that have asked their questions. I don't think really that I have got an enormous amount to add, apart from the fact that, and this is really covering what Ian and the last speaker said, and that is that the PAS is an evolving document, and it's going forward, and as this dynamic situation of piracy off the coast of East Africa and West Africa develop, inevitably we will have to develop with those, but also taking into consideration all other bits of legislation, etc., that come along. And just to back that up, and this is really to pick up on one thing that John said about GuardCon that has been established for the West Coast. Actually, that isn't the case, and the very reason why it is not the case is because it is such a fluid situation out there, and BIMCO have decided that it's impossible to do that at the present time. And I think the last thing is I would just like to quote from something that Douglas Guilfoyle said, Dr. Douglas Guilfoyle, about the use of soft law, and the way in which it seems to become more important and get greater, I suppose, prevalence in many ways. And he said the most important impact of Somali pirates as agents of change has not been on substantive law of piracy, but through generating new models of cooperation and soft law. And I think that's definitely what we've seen. I think that we all need to be looking to what the future holds rather than trying to take it back to what it was in the past. And I think that that's a very, very important thing, that we all need to be looking for a new direction in which we're going to go, rather than possibly trying to go back to something which it was in the past. I'm not inferring by that either of the questions were suggesting that. I'm just trying to say that looking forward, that's what we ought to be doing. Thank you.
Thank you, Peter. David, would you like to make some closing comments?
I'm not going to add. Yes, thank you. And thank you to Chris for that question. I think Peter has covered the majority of the answer. Suffice to say that I am aware that next week within MSC 93 here in London at the IMO, the issue certainly submitted by a number of stakeholders, the issue of 28007 is being raised. Other than that, I have nothing further to add. Thank you.
Okay, thank you. And John, any closing remarks from your end?
Not much to add other than just to sort of reiterate what's already been said. This is, I think, the proliferation of standards and groups and associations is emblematic of sort of the broader fact that it's significantly easier to develop a system of regulation than it is to implement and enforce it. And I think that what we have here is almost entirely an issue of coordination and enforcement and industry uptake, which is maybe less exciting for us lawyers than we'd like it. But I also think that it just reflects the sort of freedom of movement and just general flexibility in the maritime sector, and irrespective of what sort of the title of the document that ends up carrying the day, which again I don't think we'll know for a number of years perhaps, is that question should be subservient to the question of sort of practical effectiveness, practical ability to enforce, which is ultimately at this point a question of industry uptake. So those are the things to keep an eye on.
Thank you. That's very useful. And I think in some ways you also brought us full circle back to where we started with Peter, and indicating that perhaps some of that proliferation has to do with the nature of the maritime industry, which I think Peter's, I'm forgetting now who he cited, but the industry being something close to a perfect market, which, when governments aren't involved, perhaps that increases challenges in regulating. So we're at 3 o'clock now, so thank you to all of our presenters, David, John, and Peter, and to John for helping us with the carrying this out technically, logistically. I'm sure our audience is on mute, but I'm sure I hear them clapping virtually for you guys. Just a reminder to everyone that we will be posting this webinar as a recording on our website. So if you have any colleagues or friends who may have been interested in hearing this and hearing these excellent presentations, please feel free to let them know about that. And wishing everyone a good remainder of the day. Thank you, everybody. Take care. Bye-bye.